Hello, this is Scott Horton. Just opening up the webinar now for attendees to join. It is a few minutes before the scheduled start time. The slide presentation should be up. The topic today is criminal records and employment background checks. We will get started in just a couple of minutes. It looks like attendees are starting to join the room. Welcome. You should have access to a chat window, and you should be able to see the cover slide for today's presentation, criminal records and employment background checks. We will get started in just a couple of minutes at the scheduled start time. In the meantime, please make sure you know where the chat function is. That's where we will be able to see your questions that I will answer probably at the end of the presentation, just to keep things moving. Again, welcome as you're joining. This is Scott Horton. I'll be presenting today's webinar. Hopefully everyone can see the cover slide, criminal records and employment background checks on your screen, and you have access to the chat window. If you have any trouble viewing the presentation, you may want to close out of other applications, just so your computer can focus on its resources on this. Again, there's a slide presentation that you should be able to see. The cover slide right now shows criminal records and employment background checks. Don't break the law when hiring. My name and the name of my law firm. You should also have a chat feature so that you can type in if you have questions as we go. I will answer questions at the end. Also, the slides will be available at the end of the presentation. I can give you a link to the slide for your future reference. Again, I encourage you to type in questions as you have them as we go, but to keep things moving, I will probably wait until the end to answer questions. We will go for about an hour. Subject to the number of questions that we have, but I will do my best to stay on for a reasonable amount of time to answer any questions that may be coming in. So we'll get started in just about a minute. I thank you all for joining us today. If you've just joined, we are about to begin. Just going to give another minute or 30 seconds or so for anyone else who's signing in right at the designated start time here. Okay, good afternoon, everyone. Thanks for joining us. I have 3 clocks in front of me that say 12 noon, so I will go ahead and get started. My name is Scott Horton. I am the founder and attorney with Horton Law PLLC, and today's presentation on criminal records and employment background checks don't break the law when hiring should last approximately an hour. I will probably reserve most questions for the end, but don't hesitate to type those into the chat window as you have them. That's what I'll be using to pull the questions that I will answer. I don't want you to forget them though. So type them in when you have them, but to keep things moving, I will again try to save them until the end unless it's very specific to what I'm going over at the time. The presentation slides will be available to you at the end. You will have the opportunity to click a link to access them right away. You will also get a follow-up email and receive the slides, access to them that way, probably within about the next 24 hours. The last couple of webinars that I presented have focused more on ending the employment relationship and topics related to that subject. So this time I decided to focus primarily more on hiring and the beginning of employment. So that's where we're going to focus. However, some of the items that we're discussing also apply to the employment relationship as it's ongoing, so for existing employees and not just applicants and the hiring process. As always, I have to disclaim, even if I do represent your organization as your attorney, I cannot give any legal advice through this presentation, so I'm giving information about laws and related to laws, but if you need specific legal advice, then you will have to contact an attorney separately for that. So first of all, just briefly, I don't think we need to spend too much time on this. Why do employers perform background checks if they do? Several reasons, which I've listed here. One, you're hoping to reduce theft and fraud. Employees with criminal records perhaps are more likely to engage in inappropriate and costly conduct at work. You also want to limit employee turnover. Ideally, when you hire someone, you should be able to keep them as an employee for a while, and if they have had a checkered past, it may be the case that they're less likely to last as a good employee. The next item I would note is that you're trying to promote a safe work environment. Certainly there are some crimes of a violent or physical nature that may suggest that someone would not be safe to have around the workplace, maybe depending on the nature of the workplace and the work to be performed, whether they're working close with others or not. And then another more purely legal reason to perform background checks is as a check against possible negligent hiring claims. These cases are not particularly prevalent in New York in my experience, but it is possible, for example, that someone would file a lawsuit against your organization saying that some injury, damage to person or property resulted because your organization hired someone and put them in a position that they should not have been in if you had known more about their background. So doing some form of check on a person who is applying to work with your organization is probably the minimum, and the question is, how far should you go? And this likely depends on the nature of the work to be performed, the nature of the business, etc. So we'll mention some of those things as we go forward. Now, a couple of starting points. Everyone who has registered for this, to my knowledge, is based in New York. That's where I practice. So I will be focusing somewhat on New York laws, although some federal laws that apply more broadly as well. So just know that if you have employees in other states, that you're responsible for it, you may be subject to different laws peculiar to those states. In New York, where most of you at least have some employees, the New York human rights law prohibits employers from even inquiring about arrest records that did not lead to conviction. So someone was arrested, but the charges were dropped, or the case was prosecuted and the person was found not guilty, then those cannot be the basis of employment decisions in New York. Specifically, the New York human rights law prohibits employers from both inquiring about and acting adversely upon any arrest or criminal accusation, not then pending, which was followed by a termination of that criminal action or proceeding in favor of the individual. So if there is an arrest currently pending, the law doesn't prohibit you from asking about that or taking action based on it, with the theory that a pending criminal matter could be relevant regardless of the outcome. The prohibition comes in once the charges have been resolved in the individual's favor. So that's just background. We're going to really spend most of our time talking about applicants, or to some extent employees who have criminal convictions in their background, not just arrests that were charges were dropped or that were resolved favorably. There are some limitations on youthful adjudication, so juvenile offenses where records are sealed and the like, that restrict employers from prying into and making employment decisions based on those. Another important starting point is that, at least in New York, job postings cannot indicate that applicants must have clean criminal records. So there have been a number of cases filed with the New York State Division of Human Rights over the years that I'm aware of, where companies had put right in their job postings, whether it be in the paper or online, for example, that the company will not consider anyone convicted of a felony or anyone with a criminal record, etc. Any sorts of per se exclusions like that in your job postings are a no-no, because the mere fact that you put it in there alone could provide someone the basis of a claim. And there are people who just go around looking for these ads, and whether they actually apply or not, filing a claim with the New York State Division of Human Rights. And it's a pretty clear violation of the law, so you end up usually having to settle those, even if someone had no intention. All right, I just had a note that the sound dropped. Is anyone still able to hear me? Please type in the chat if you can still hear me. Okay, so it looks like some people can still hear me, so you may want to try logging out and logging back in. And again, you should also check and see if you have other applications running, then that may be slowing down your feed of this presentation. So see if there's something else you can drop. All right. So again, as I was saying, just putting that in your job postings alone can cause trouble for you. There would be very limited exceptions, perhaps, if you were in an industry or that's somehow regulated or requires licensure, that you would be excluded from hiring based on a criminal record. But in those cases, it's better not to focus on the criminal record, but rather focus on the requirement of being licensed or accredited, etc. And I'll bring that back up in just a minute. So the next stage, so after you haven't either posted in your job postings, anything about criminal records, and you haven't done anything to ask about arrests, the next level of sort of restriction, I suppose, is the emerging field of ban the box laws. So most of you are probably familiar with this now because most of you are in the Western New York, Buffalo, or Rochester areas, and both of those cities have ban the box laws in place. So I'm going to focus primarily on the Buffalo ban the box law. Rochester and New York City also have prominent ban the box laws. I'm not aware of others currently in place in New York State, but they could emerge at any time within other jurisdictions. There are some states that have similar laws, but New York State has not adopted one yet. But what these ban the box laws generally do, the name is based on the idea that some employers have had literally boxes on their job applications that say, have you been convicted of a crime or have you been convicted of a felony? You know, they may or may not have a time period restriction. Have you been convicted of a felony within the past 7 years, etc. These ban the box laws based on a nationwide movement have specifically targeted those questions on written job applications, but they go further in most cases than merely banning the box. So just spend a few minutes on the Buffalo law in particular. The coverage issue is important. Buffalo's ban the box law applies to public and private employers within the city of Buffalo with 15 or more employees. So some of you probably fall into that category. Others of you are near Buffalo but do not actually have employees working within the city limits. As that employment provision reads, you are not subject to Buffalo's ban the box law. However, there is also a provision that covers any vendors of the city of Buffalo, regardless of where they're located. So if your business is a vendor for the city of Buffalo, and this will be true, for example, of Rochester's law as well, then the law says that you are covered and prohibited from engaging in these questions early in the application process. Specifically excluded from coverage, however, are public or private schools or service providers of direct services specific to the care and supervision of children, young adults, senior citizens, or the physically or mentally disabled. And those exclusions would apply to some of the folks in this webinar right now. So I note those. However, the fact that the Buffalo ban the box law does not apply to your organization does not mean that you can ignore everything else I have to say, because much of what I'm discussing does still apply. There's just not a law in Buffalo that says you can't ask the question about criminal convictions early in the application process. Where it does apply, Buffalo's ban the box law prohibits covered employers from asking about criminal convictions before the first job interview. So that's why I said it's not strictly just on the application, the box or question that you might find there. You know, if there were other requirement that they provide this information before an interview, then that would also be prohibited. For example, you know, asking someone outside of an application, for example, in the job posting, to include in their submission for consideration for employment information about prior criminal convictions. Job applicants can directly sue employers for violating this law and can receive injunctive relief, damages, and attorney's fees. There are penalties of $500 for the first violation and $1,000 for each violation afterwards. So if you are a bigger company in New York, within Buffalo city limits, then you could be on the hook for significant liability if you are violating this law on a repeated basis. And finally, just to note that beyond the exceptions already mentioned, the law itself does also provide a general exception where there's a specific legal restriction on the applicant's ability to perform the job, such as positions in schools or police department. The scope of that could depend on many things, but again, be careful in asking about these types of convictions too early in the process, because there still are all the other restrictions that we're going to be talking about. Just briefly, Rochester has basically the same law as Buffalo for a lot of practical purposes, except that it applies to public and private employers within the city of Rochester with as few as 4 employees, so a lower employee threshold there in Rochester. And again, it applies to vendors. The law also specifically says it applies to contractors and suppliers of the city. So if you happen to fall into those categories, then you need to know specifically about Rochester's ban the box law as well. But again, the scope is more or less the same as Buffalo's law. New York City has the broadest of these laws. It's called the New York City Fair Chance Act. And again, it applies to employers with 4 or more employees within the city of New York. But it goes beyond questioning before the first job interview and says that covered employers cannot ask about criminal records until after they have made a conditional offer of employment. So in other words, beyond the interview process, once you make an offer of employment conditioned on perhaps in some situation passing a physical or drug test or something like that, at that point in time, you could then review criminal records after you've already told the employee that you're going to offer them the job, as long as the criminal record check comes back clean, for example, or whatever other screening you're going to do. And at that point, you will have to also tell them and get their authorization to conduct the criminal record check in most cases based on something we're about to get to. And that is the Fair Credit Reporting Act. Before I get to the Fair Credit Reporting Act, I want to throw up a poll, just do a couple of these. I'm going to put up a poll. Does your organization use criminal records in hiring? If you'll just quickly check yes, no, not sure. This is completely anonymous. I won't know who clicked what, and no one else will. We'll just get an idea as to what most people are doing. So far, we have 100% yes. My organization uses criminal records in hiring. That's not surprising. I didn't, and I won't take the time to ask the more detailed question of, what percentage of your workforce do you do that for? It may be that you do it for some positions and not others, and that might be okay under the circumstances. But good. So that either why you are here, or just makes clear that this is relevant content to you. But thanks for answering that question. And now, the Fair Credit Reporting Act is a federal law that applies to all employers across the United States. New York also has its own Fair Credit Reporting Act. I don't want to get too legalistic on this, but there are some complicated questions of possible preemption between the federal and state Fair Credit Reporting Act. But the laws are largely identical. The New York law is clearly based on the federal law. A couple nuances that I'm not going to spend time on here, but may warrant consideration in a special situation. But so I'm going to focus on the federal Fair Credit Reporting Act and what it means with respect to criminal record checks. The Fair Credit Reporting Act also pertains to credit checks. It's possible that some of you are doing credit checks of your employees in certain positions, and the law applies as well in that situation. It applies anytime that you're getting a consumer report from a consumer reporting agency. So we need to talk about what those mean. A consumer report is any written, oral, or other communication of any information by a consumer reporting agency bearing on a consumer's credit worthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living. You see a lot of emphasis on credit. I mean, this is what the banks have to comply with in reviewing your credit before they give you a loan, for example. But then you see the references to character, general reputation, personal characteristics, etc., which is broad enough to encompass criminal record information. It's also broad enough to include, just information about what kind of person is this. Sorry. Suddenly I'm getting notifications popping up, so I apologize for those dings there if you heard them. The important component of this definition is the reference to consumer reporting agencies. And briefly, that means that you need to be considering whether you're getting third-party report. So if you within your organization call up a former employer of the applicant and ask information about that person, you are obtaining information about their general reputation, character, personal characteristics, etc., maybe one or more of those things. But because you are not then a consumer reporting agency, there's no implication of the Fair Credit Reporting Act. The consumer reporting agency then is any person which for monetary fees, dues, or on a cooperative nonprofit basis regularly engages in whole or in part in the practice of assembling or evaluating consumer credit information or other information on consumers for the purpose of furnishing consumer reports to third parties, and which uses any means or facility of interstate commerce for the purpose of preparing or furnishing consumer reports. So that's a long, fancy definition, but what it really means for all of your organization's sake is if you hire some other company to provide you reports about applicants or employees, then you have a consumer reporting agency providing you a consumer report, most likely. I did a webinar a little while back on social media and hiring, and there I noted that companies that would compile social media information about individuals and then sell that information to employers, so sort of social media background checks, have been found to be consumer reporting agencies as well. So it's not just credit information or criminal record checks, it's any types of background information about a person that you obtain from a third party who qualifies as a consumer reporting agency. Now, if they're just a friend of yours who happen to provide you some free information, like I know this person, you might not want to hire them, or conversely, I know this person, you do want to hire them, that's not likely to qualify as a consumer report, even if they did put it in writing and send it to you by email, for example, because that person is probably not a consumer reporting agency, assuming they're not regularly getting paid and to sell this type of information. Why is all of that important? Because once you have a Fair Credit Reporting Act consumer report, or you're going to be obtaining one, I guess I should say, then there are other requirements that you have to comply with. So in other words, before you get a background check from an outside vendor, a credit check or a criminal record history, for example, you have to provide written notice and disclosures to the applicant and obtain their written consent and authorization for you to obtain that information. Now, this doesn't mean that the applicant has the right to say, no, I don't want you to get that information, but you still have to consider me for employment, they do have a right to say, no, you can't obtain that information. But then at that point, presumably you would not consider them further for employment, and there's no problem with that as long as you don't somehow do it inconsistently and discriminate on some separate basis. But another important component here is that based on an amendment to the Fair Credit Reporting Act from a number of years ago, you have to give this disclosure and get this authorization in a separate written document. There was a trend of employers putting the disclosure and getting the authorization on the employment application itself, but that is now clearly not acceptable. There need to be standalone documents. Most commonly, if you're contracting with a criminal record check company, they will provide you the forms that you need to get signed, and you just need to make sure you hand those to the applicants and get them signed before you do obtain the background check. Ideally, the consumer reporting agency wouldn't be providing you the information until they confirm that you have received that authorization. But my impression is that there's not always a formal check on that. There's just something contractually between your organization and the vendor that says that you know that you're supposed to get that authorization and that you've done that. But if you do have a system where you are required to at least confirm that you've received the authorization or provide authorization or something, then that's a good check to make sure you don't get yourself into trouble. Once you get the background check, the criminal record information from your third-party vendor, you obviously want to review it, or else you wouldn't have received it in the first place. Suppose after you consider some more things that we're going to get to, you decide we're not going to hire this person based on information in this criminal record history. Then you must first provide the person a pre-adverse action letter, letting them know that we've obtained the criminal record or credit information, whatever it is that you've obtained from a consumer reporting agency. Include a copy of the report, the criminal history that you received, and a description of their rights under the Fair Credit Reporting Act. Some of the required documentation may be provided to you by your vendor, or you can obtain it, I think, through the FTC. The Federal Trade Commission has on their website the description of rights under the Fair Credit Reporting Act. But so you package all that up to let the person know, based on what we've reviewed here, we plan to not hire you. You then have to wait 5 business days before officially taking the adverse employment action, i.e. not hiring them. I mean, in the non-hiring situation, not a big deal about taking the adverse action in the sense of you're under no obligation to hire them in the first place. You don't technically have to send them something saying we're not going to hire you. But note that all of these requirements would also apply in the case of an ongoing employment situation, perhaps if you're considering a promotion, or for whatever reason you do routine background checks on your employees and find something and decide to hire them or fire them based on that. This would apply, and you would have to wait 5 days before taking that action. Idea being primarily that if there was something inaccurate in the background check that you obtained, they could point that out and get it corrected before you take the action. Then, for whatever reason, the way this is written into the law, after taking the adverse action based on the criminal history you received, for example, you have to then provide the contact information of the consumer reporting agency and another statement of rights. Likely they're going to have that information already from the pre-adverse action documentation you provided, but again, you do have to provide that again. All right, now I'm going to tie in some specific New York law now. Remember, the Fair Credit Reporting Act's a federal law, although there's a New York counterpart that's more or less the same. But let me give you a quick overview and then more detail of the process for New York employers. You obviously have to get the authorization, and then you obtain the background check, and then you're going to review it. But under New York law, you're going to have to specifically consider the relationship between the position they're being considered for and their criminal offenses, and whether the employment would create an unreasonable risk under the circumstances. Because there is an established public policy in New York in favor of hiring employees with criminal record to, get employees or get employment for people who have been convicted in the past rather than keeping them unemployable, you have to specifically and affirmatively weigh 8 factors in determining whether any criminal conviction is a disqualifying event for employment. And then supposing that you do reach that conclusion after conducting the analysis, you would, upon request of an applicant, have to provide a written statement of reasons why they were denied employment within 30 days. I'm going to go into each of these pieces in more detail. I just wanted to give you the overview. So there's something called Article 23A of the New York Corrections Law. That's what we're going to be talking about here. The law comes in specifically when you're making employment decisions based on criminal convictions that predated the beginning of employment, which is generally always going to be the case in the initial hiring situation. That, if they have a criminal record, it obviously arose before they were hired because they have not yet been hired when you're considering it. But for existing employees, just so you know, this law does not prohibit or does not apply really with respect to convictions that occurred during employment with you. Idea being that, something that they've done while they're employed is more germane to their employment than something that happened in the past pre-conviction. There are situations where that distinction becomes important, and it's somewhat little known, even among those who understand that this law is out there. So that's why I wanted to point it out. So the law basically starts by saying that employers can't refuse to hire people based on previous criminal records unless there is a direct relationship between the previous offenses and the employment sought, or employment would present an unreasonable risk to property or safety. Easy enough to say, well, yeah, those are the reasons why we wouldn't hire someone based on a criminal record, but the law puts you further to your proof of that and requires that an employer specifically consider these 8 factors in reaching the decision not to hire someone. Real briefly, I just want to note that the very same law also applies with respect to licensing within New York State. So, for example, with respect to a teacher's license or some form of liquor license or any other licensing issued by the state, people cannot be automatically excluded based on past criminal convictions, and the state agencies have to consider this. So if you are employing in positions that require licensing, recognize that to get the license in the first place for convictions that predated the licensing or perhaps renewal of the licensing, the applicable state agency should have considered this, or at least would have had to have if they had rejected the licensing. So that's just a parallel factor there. So if, for example, somebody comes to you with the license necessary to do the work, and you then get their background check and decide that you don't like their criminal history, so you don't want to hire them, you may be in a vulnerable position based on the fact that the state agency that issued the license may have considered the same factors and reached an alternative conclusion. So you would want to be perhaps on heightened alert there to make sure you're doing the analysis objectively. So here are the factors. First of all is the general policy encouraging employment of persons with criminal records. That's always on one side of the equation. The others can go either way in certain circumstances. It's really a balancing act. No one factor is ever determinative, and there's no mathematical formula for how you do this. The most important thing is before you decide not to hire someone or potentially decide to let someone go based on a pre-employment criminal conviction, you need to do something to make it clear and document that you have actually evaluated these 8 factors. I think that's going to help you in most cases significantly. It's still possible that an employee will prove that you made the wrong conclusion, but if you can show that you at least made the analysis, you're going to be way ahead of most employers that get claims of violations of this law. So other factors are here: specific duties and responsibilities of the position, obviously, bearing of the offense on the ability to perform the job. Some of these are kind of similar, but then the time elapsed since the criminal offense. Was it something that happened 3 months before they're looking for the job, or 3 years, or 30 years? Obviously, the more time that's passed in most cases will mean the more reasonable it would be to employ them. The age of the time of their offense, is it something that they did when they were 19 and now they're much older? Or is it something that they did in their 50s and now they're still in their 50s? Again, kind of consistent with the time elapsed, but you can imagine some scenarios where it could make a difference. Time elapsed between 45 and 50 might be that much less relevant than time elapsed between 19 and 24, I suppose. The seriousness of the offense, is it a felony? Is it a misdemeanor? Was there a long prison sentence resulting from the conviction, or, did they just get put on probation? Sorry, some more alert came through. Information related to rehabilitation and good conduct. In some cases, courts will actually issue certificates of release or of relief from conviction, etc. So whatever information the person has, I suppose with a drug conviction, information related to rehabilitation could literally mean going through a rehab program. And then the employer's interest in protecting property, safety, and welfare. Oops, it jumped ahead too far. So again, you have to do the analysis. I would document it. You don't normally have to give the analysis to the applicant. You just have to comply with whatever notice requirements there are under the Fair Credit Reporting Act about we received this information, and based on that, we decided not to hire you. Here's where we got the information from. But the corrections law in New York does also say if the applicant asks why they were denied employment, then you have to provide them a written statement of the reasons within 30 days. That's kind of vague in the sense it doesn't say how specific you have to be. Can you just say, well, we didn't like what we saw in your criminal history? There's not a lot of guidance on that, but just know that, if there is a request, you have to do something at least to satisfy that obligation. Certainly give it careful consideration when it happens. Not that common that an applicant actually asks at that point, but there is that obligation there that goes beyond the Fair Credit Reporting Act. There are a couple other notice requirements related to Article 23A. Again, that's the section of the corrections law that applies here. First, you have to have a posting in your workplace, so your minimum wage and FMLA, if applicable, and your workers' comp posters, all those types of things that you have. In the same place, you have to have a notice regarding 23A. I think you actually have to include and post the text of the statutes itself, which, probably not the most logical information to be providing to your employees because it's written like other laws and not super easy to read, but that's the requirement. Then there is a requirement that you specifically provide a copy of the statute itself to an employee when you receive a consumer report that contains criminal conviction information. So if you do a background check and there's no criminal conviction information in it, then fine, no obligation to give the employee a copy of Article 23A. But if there is criminal conviction information, the law in New York does require that you give them a copy of Article 23A so they know their rights in case that you would take adverse action against them. However, the law applies even if there is no adverse action taken. So under the Fair Credit Reporting Act, if you receive a third-party background check with criminal record information, you would be required to make certain notices upon deciding not to hire the person based on the information. In New York, there's an additional requirement to give Article 23A rights, even if you did, for example, decide to hire the person despite their criminal record. The New York Human Rights Law, which most of you are familiar with, which is the law that generally prohibits discrimination in employment, among other things, on the basis of race, sex, age, national origin, religion, a couple dozen different categories, specifically prohibits discrimination in employment on the basis of these corrections law provisions that we've been talking about. So employees who feel that they've been denied employment or let go from employment based on a criminal conviction without proper weighing of those factors that we talked about under the corrections law can go to the New York State Division of Human Rights and file a discrimination claim on that basis. If that happens, that's where you definitely want to be able to show the Division of Human Rights that you plainly evaluated those 8 factors. Historically, the Division of Human Rights has placed a lot of emphasis on the first factor, the state public policy of employing people with past criminal convictions, and required, therefore, some fairly strong nexus between the offense and the nature of the job. So, for example, an employee who robbed a bank relatively recently probably doesn't have to be hired as a bank teller, but someone who robbed a convenience store of some, food items, for example, without using, a gun and without causing violence, several years later may not justify denying employment, working as a lifeguard, for example. You can't just assume that some prior bad act is sufficient to disqualify the person from employment because of this law and the factors that it applies. So again, corrections law violation is a specific protected category under the human rights law. The human rights law, again, which allows you not even to inquire about, much less base decisions on arrests records that didn't result in convictions. I just want to note here too that in New York, Obviously, race, sex, age, disability, and other forms of discrimination are illegal. It is possible that someone would claim race discrimination on the basis of being denied employment allegedly because of their employment history. Their criminal history. In other words, the theory being that individuals of certain races are more likely to have criminal records and therefore screening out applicants based on criminal history may disproportionately impact employees of certain races. That is a theory that might support a claim of disparate impact discrimination, is what it's called under the human rights law. Likewise, men have more criminal convictions than women, and it's also possible that other categories, just for instance, age or disability, might somehow correlate with people that you deny employment based on criminal records. So if you happen to have a string of 50-year-olds who you've denied employment based on their criminal records, and at the same time have hired a number of 20 or 30-year-olds who had similar criminal records, then it's possible that someone could claim age discrimination on the basis of your decisions, even though you say it's based on the criminal record. So obviously you'd want to be able to explain why the older employees denied employment based on their criminal records were distinguishable for other legitimate reasons from the younger applicants. And I just added up here any other protected category. So again, just don't stop completely at the analysis of we've weighed the 8 factors and we don't think we should hire this person, but make sure that you're applying those factors consistently among various demographics and populations of applicants. Just to give you the other side of that, those types of disparate impact theories and the observation that individuals of certain races or national origins are disproportionately affected by even neutral hiring policies based on criminal convictions all really got brought up with a 2012 enforcement guidance that the federal EEOC, Equal Employment Opportunity Commission, issued. So they put out this long document that got a lot of attention at the time, basically requiring employers to undergo an individualized assessment and weigh a bunch of factors before hiring, or not hiring, I should say, employees or applicants based on criminal records. It wasn't as big of a deal in New York because the New York corrections law was already there with its 8 factors. Not all of the factors line up exactly, but the underlying point being that the federal discrimination laws don't specifically protect applicants with criminal records, and this was the EEOC kind of using the existing prohibitions on race and national origin or other forms of discrimination to protect applicants with criminal records, even where state laws didn't specifically protect them. But again, not as big of a deal in New York because there were those protections in state law. The most recent activity on this, the guidance is still out there, but it was ruled unenforceable by a federal judge in Texas in February of this year. The ruling was limited to Texas specifically, but the first specific ruling saying because the EEOC issued this, not going through proper procedures, etc., they can't enforce it in Texas. But it's at best an open question as to how eager the EEOC in 2018 is to enforce this document anyway, which came under the previous administration. But I just wanted to put that out there, especially for any of you who remember when this was a big deal 6 years ago. Even then, again, acknowledging that it was less a big deal in New York than elsewhere. Texas, for example. All right, so we're going to move on to questions in just a minute. So start typing those in and I will be happy to answer them. I just throw this up to let you know that I did write this book that is available on Amazon or barnesandnoble.com, ebook or paperback version. Not a hard sell here, just I have had clients who have enjoyed having it as a handy reference on their desk. It discusses a lot of things that are important to New York employers, including a lot of this information that we've talked about. There's references to the ban the box laws in Buffalo, Rochester, and New York City, and the Fair Credit Reporting Act requirements, for example. It also talks about dealing with unions, minimum wage and overtime issues, workplace harassment, discrimination claims, and various other things. So I just want to mention that it is out there, easy to find on Amazon or barnesandnoble.com. But now we will take questions. I'm still going to give you the link to the slides as well. In fact, I'll do that right now so that anyone who has questions has time to type those in. Okay, so you should now or momentarily have a link available to get the slides, to download those for your future reference. And again, you'll also get an email if you've registered for the webinar to give you the link to that one more time, probably tomorrow. All right, I don't see any questions in the chat yet, but I'll give you time to gather your thoughts. You know, I'm willing to go a little bit off topic too, if there's something related to hiring that I didn't quite address here. Again, recognizing that your name's going to be attached to your question, so don't ask anything too confidential. You know, there won't be any attorney-client privilege right here, but if it's something of a general informational nature. Okay, we have a question. Why is it such an issue to make the hiring decision based on the former criminal history? Follow up with another question if you want. I'll try to answer it generally, but I'm not sure which way the question is sort of angled. Why is it such an issue? From my standpoint, it's such an issue because the laws are out there, and if you don't carefully follow them, then there can be significant potential penalties, and the way the law is applied, you know, everything tends to err in favor of the employee. So if you misstep or don't have strong factors weighing against hiring someone, then you probably shouldn't use the criminal record against them in the hiring process. But again, if your question was coming at it from, you know, a different angle, you know, feel free to clarify. The other thing I should note, maybe I didn't earlier, although I addressed similar things, is that if you happen to get criminal record information through your own employees, if you go online and just do a search, or you contact the police department or something like that and get criminal record information that way, then you wouldn't implicate the Fair Credit Reporting Act. So you don't have to get the employee's authorization, and you wouldn't have to give the same notices, but you would still have to weigh the factors under the New York corrections law and you would still have to give the notices required there. Yeah, so I feel it should be more discretionary decision on behalf of the employer. Well, yeah, I'm not really here to disagree with you on that. I'm just telling you what the law says. It's been in place for quite a while. So again, that New York policy in statutory form, and the only way to change that is to contact your legislatures and try to get more discretion there. But I will note that, as practical advice, I think knowing that the law is there and documenting that you weighed the factors is a big step up on many employers who end up getting themselves in trouble. Not to say that it's enough to just document the factors and then automatically say we're not going to hire the person. But certainly if you receive a claim of violating the corrections law and not considering the factors, and you can't show that you considered the factors, then you really have an uphill challenge overcoming that. So there's still a number of you on, and if anybody's typing out a long, complicated question, or if anybody else has any short questions or whatever, I'll give you another minute or so to type those in. Again, I'm happy to stay on as long as it takes to answer the questions. Here's my contact information if any of you think of something afterwards and want to follow up, or there's something more specific to your company that you want to raise with me. While I'm just seeing if there's any more questions, I'll just throw out there for you. There is also something called an investigative consumer report that's not strictly speaking just here's the report on their criminal record history. If you were to hire a third party, a consumer reporting agency, to go out and ask people questions about an individual or something like that, and then provide you the report on them, then there's something called an investigative consumer report that would probably be generated. There are some slight nuances on that, which I only mention because if you get in the situation of having a third party provide you a report based on interviews, etc., of a current employee based on employee misconduct, investigating employee misconduct through a third party consumer reporting agency. If you happen to get into that situation, there may be additional things to consider, but it's a little beyond the topic today, but I just wanted to throw that out there for you in case you happen to get there. Anyone else have any questions? If by chance you've asked a question and I haven't answered it yet, then please type it in again. I've answered the questions that I've seen. Okay, well, if there are no more questions right now, or maybe no more questions that anyone wants to ask in this forum, that is fine. I appreciate your time. Many of you stuck with us throughout the hour here, and I think this information is helpful. By way of background, many of you are probably largely complying with these requirements already, but to have the reminder and to make sure that you are not missing some of the technical details could save your organization a lot of time, money, and other hassle in the long run. I do these webinars not quite every month, but usually tend to be maybe 2 months out of 3. So you will get the information about upcoming webinars. If you have any information that you would like me to discuss, or I should say topics that you would like me to discuss, I can't make any promises, but let me know and I'll do my best to fit those into the rotation. But again, I really appreciate your time. Hope you found this helpful and look forward to seeing you in future webinars or talking to you through other means. Thanks and have a nice day.